Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us. Today we're going to be talking about bankruptcy, Chapter 7 and Chapter 13. These are tough economic times. Things are not getting better in this country, and a lot of people are needing to invoke the federal law to get some relief, whether it be a fresh start or a reorganization under Chapter 13. Joining me today to talk about these issues, my co-host Jesse Barrientos. Jesse, how are you?
Very good, Dave. How about yourself?
I'm doing well. Jesse, one constant in this country right now is unemployment figures. It's rough. People are having a hard time finding work. Some people have walked away from work. Taxes are going up. The cost of living is going up for the most part. And there's some tough economic times that are causing a lot of stress in people's lives. Thankfully, the federal government has bankruptcy laws which give people an opportunity to either get out of debt in certain circumstances or a repayment plan if they're trying to save property and keep what they have and repay some of their creditors. So thankfully, there are laws out there to protect people in these tough economic times.
You have a vehicle. There's nothing as certain as death and taxes, right, Dave?
Right.
So, let's just start off. People refer to this, a couple different ways: fresh start, complete discharge. What's a Chapter 7?
Well, Chapter 7 is the most common form of bankruptcy. About 75% of the cases that are filed are of the Chapter 7 variety, and that's known as the fresh start bankruptcy. Chapter 7 is where someone has very little in the way of assets and a lot of debt, whether it be credit cards, medical bills, personal loans, past due utilities, auto repossessions, foreclosures, whatever it might be. Chapter 7 is a way to eliminate the majority of one's debt, move forward, get a fresh start. Some exceptions, not every debt's eliminated, but Chapter 7 would allow, in most cases, either a fresh start completely or the majority of the debt being eliminated, and life goes on. You're able to wipe the debt away and start fresh.
And I know I'm going to ask you this kind of a general blanket question, but when and why would somebody want to file a Chapter 7? I mean,
well, let's say someone who has just lost their job or had an illness or gone through a divorce, some kind of drastic financial situation that all of a sudden took money out of their pocket or took income away.
So would that discharge attorney's fees, Dave?
You can discharge your own attorney's fees.
That's right.
Yeah, you got to be careful with court orders on other people's. But basically, someone who's been living on credit cards, maybe they took out cash advances, maybe they went and got a payday loan or a title loan, and just they're not able to make ends meet. They've been making minimum payments on the credit cards maybe, and now it's to the point where they can't even make the minimum. So you're going to have a late fee over the limit fee. And of course, creditors, when they don't get paid, they have collection mechanisms. And that's harassing phone calls, lawsuits, garnishments, bank citations. They have a way of not only getting a judgment against you and harassing you, but actually taking whatever little you do have on account or wages.
Dave, you mentioned payday loans, and that's, I guess, maybe unfortunate that's very, very popular. So we get a lot of people that come in and they're essentially being garnished. There hasn't been a lawsuit that's been filed, but they borrow whatever amount of money, and that is coming out of their paycheck voluntarily. So do you have to wait to file the bankruptcy to take care of that, or what can you do?
Well, unfortunately, when someone visits a payday loan store or a title loan store, they're in a situation where they've typically exhausted all other forms of credit. So there's no more room on the credit card. They can't get a traditional loan from a bank. They can't get an equity line. There is no more money. They can't borrow from family or friends. They're at the last resort. And they go to these stores that will give them money in exchange for repayment of that money at a premium.
Huge premium.
Yeah, anywhere from 100% to 500% or anywhere in between. And what happens is the people typically can't make that loan repayment back, and they'll roll the payday loan over to another week, to another cycle.
And it continues to build up.
Increase the fees. So when you get into that situation as a consumer, one of two things is going to happen. You're either going to come into some money and be able to pay it off, or more likely than not, you're going to fall deeper into debt and eventually have to file a bankruptcy to just wipe the slate clean. But you want to file that as soon as possible once you're in that terrible situation of owing payday loans. At that point, you're already at the panic mode.
Right.
So you really need help. You need to talk to a professional to find out what your rights are at that point.
Before you file a bankruptcy, is there anything that a litigant, a person, debtor needs to do?
Yes, things have changed. There are some requirements that one has to go through before there's eligibility to file. The biggest one is a credit counseling session.
Oh, so I'm in the situation I'm in because I didn't have credit counseling.
Well, the government feels you need to go through credit counseling because maybe there's a non-bankruptcy alternative that you might choose. You want to go through the credit counseling, which is a means to an end. In addition to that, you'd have to provide your most recent federal tax return if you were required to file. And if you have paycheck stubs, your most recent 2 months of those.
You have to submit that to?
You have to give that to your attorney, who's going to then submit it to the trustee in your case, just to verify the information and make sure that you are eligible, and that the information in your bankruptcy petition, which is prepared by your attorney, is accurate and truthful. So they want to cut down on the very little amount of fraud that exists out there for people who really have the ability to repay but are choosing not to anyway.
Do you have any sense of what the what the percentage is? Obviously, I was kidding about that before, but it just seems that people are backed up against the wall, and now you want me to jump through this hoop to to demonstrate what everybody already knows.
Yeah, I would say over the course of the year throughout the country, if there's approximately 800 or 900,000 bankruptcy cases filed, you may have 100 or 200 total that could be determined to be abusive to the point where they have to dismiss those cases. So it's a very, very small segment. It's not anything what the credit card lobby back in 2005 said it was. There is not massive abuse going on. Nobody sets out really to file a bankruptcy. People don't run up debt just to tarnish their credit and file a bankruptcy and have that trail them around for the next 10 years, or in some cases forever, because it has to be disclosed on certain credit applications, apartment leases, job applications. So no, there is not widespread fraud, but the government thought that there may have been some fraud. So they passed this legislation back in 2005 to try and curb it. But it really doesn't exist to any great extent. People need help out there, and that's obvious.
So what happens? I mean, if I've got, for example, let's say even a garnishment or a threat of garnishment, or maybe a creditor is suing me, and I have to go to court in 2 weeks for the small claims case or whatever for the credit card, what is filing a Chapter 7 going to do for me initially?
Well, Chapter 7, once a case is filed, there's something called an automatic stay which is created. And it basically states that the case is filed, there's a case number, there's a date of filing, and the creditors, typically, most creditors, are prohibited from taking any kind of collection action against you.
What if there's already one pending?
Well, again, depending on the type of case, but a typical credit card
Right.
or other debt collector situation, that lawsuit must stop immediately in its tracks. However, if there's some kind of contempt hearing, I always advise my clients to show up at court, advise the court that you filed a bankruptcy, and typically there'll be no contempt charges against you.
If it's based upon the repayment of whatever debt that we're talking about there.
Right. The difference between owing money and having to appear in court for failure to show up in court are two different things.
Right.
So the bankruptcy will stop the debt, but if there is a contempt hearing, I want the client to show up and advise the court that a bankruptcy case has been filed,
So it's
and
a
that there was
record.
no intentional disregard for the law in missing so many prior court dates.
In Chapter 7, what kind of debts can I expect to be eliminated?
Well, any kind of credit card, medical bill, personal loan, past due utility, auto repossession deficiency, money that was lent to you by a family member or a friend or a payday loan store. Those are the typical debts that get eliminated in the Chapter 7 without much of a problem. A problem could come in a case where someone runs up their credit cards in anticipation of filing. You know, they run up charges, they buy electronics, TV, furniture, electronics. Cash advances within 60 days of filing are a no-no because it just looks to the court like an abuse, like you knew you were going to be filing, so you tapped out all your available credit. Well, the credit card companies know about this. They know when you filed and when you charged, and if they feel it was fraudulent, they could object. And in that case, any of those recent charges would still remain due and owing.
How about, and I get asked this a bunch of times, how about a student loan?
Student loan is non-dischargeable per se. There are some exceptions, undue hardship, but those are very, very hard to prove.
My understanding is you have to be in very sad shape, that you're not able to work at all, really. And I'm not talking about a bad back here, okay? I'm talking about being completely disabled.
Right. The student loan situation is kind of just what you said. If you have the ability to repay it to any extent at all, then you're going to have to repay it.
What happens if I have the student loan and I use my credit card to pay back the student loan, and so now the debt that I have on the credit card is really what I use to pay back the student loan?
Well, the credit card company could object because that debt that you incurred was used to pay a non-dischargeable debt. And the same thing would be if you paid for non-dischargeable taxes with a cash advance that you took out on a credit card. In other words, you can't abuse the credit cards. If in the ordinary course of life, if you ran up a debt, that's one thing. But if you abuse it, run it up at the last minute, take out a huge cash advance, do something that's tantamount to fraud, plan on that debt sticking around, and if you do enough fraud, they can deny your whole bankruptcy, which is basically the death sentence. That means you could never eliminate those debts through a bankruptcy ever for as long as you live.
What other kinds of debts, other than the student loans, the things that you talked about, survive a Chapter 7?
Well, in a Chapter 7, any kind of parking ticket's going to survive, a recent tax debt, child support.
Recent tax debt, what do you mean by so are you saying that there's a possibility of getting some old taxes discharged?
Right. Taxes is a tricky area under the bankruptcy laws, but basically, in a nutshell, if a tax is more than 3 years old, if you filed a return on time or within the last 2 years, and if the tax was assessed more than 240 days ago, it may be eliminated in a Chapter 7 bankruptcy. So typically an old tax debt more than 3 years ago, we have a good chance that that debt will be eliminated. One caveat though, the return must be filed by the debtor, not by the government. The government actually does file returns on behalf of individuals. If that happens, that tax debt can never be eliminated because the tax return was filed by the government.
What if I go back and file a return from a few years ago?
You can do that, but then you must wait an additional 2 years from the time you filed that return before it could be eligible for discharge. So the timing with Chapter 7 bankruptcy on a number of different issues, the use of credit cards, the tax returns, there's a lot of time areas that you want to make sure that you don't pull the trigger on a filing prematurely. You want to time it properly, and that's not fraudulent. That's zealous representation. That's being smart. That's taking full advantage of the federal laws that are there for you. If waiting an extra week or two means the difference between dischargeability and non-dischargeability, by all means, your attorney better wait. Otherwise, you have an issue with your attorney there.
Well, let me ask you this. So, I did the pre-requirements, we filed the petition, and I'm going to go to a meeting. What's the meeting of creditors?
Well, the meeting of creditors is required under the bankruptcy code. It's an opportunity for a trustee to examine you under oath to make sure that you're entitled to a bankruptcy and to make sure that there are no assets which can be taken, administered, and paid towards the creditors. And of course, the creditors have an opportunity to show up at this meeting and witness it, ask a few questions, possibly tell the trustee about something that they may know about the debtor. For example, if there's property in Wisconsin that was not disclosed, or an old Corvette that miraculously didn't make the schedules. It's an opportunity for the trustee as well as creditors to examine the debtor under oath. And creditors can also set up their own meeting. That's called a 2004 examination. In some cases, the trustee does not have enough time to let the creditor ask questions, forever. And the trustee will say, look, bring your own motion, have a 2004 exam, you can examine the debtor on your own. I'm convinced that the debtor has no assets, in my opinion.
I've actually been on either side of that. I've represented a debtor in that situation. I've asked questions. Hasn't gone on for a long time, just a few kind of basic kind of things there.
I think it's important to note, too, on this topic that bankruptcy is for the honest debtor. So as long as the debtor is being honest and has made a full disclosure and is not hiding anything and hasn't committed any kind of fraud, that debtor should not worry about any of these procedures. It's the dishonest debtor, the one who has done something possibly shady or non-disclosure or something of that nature, maybe taking advantage of a creditor, taking a loan out in false pretenses, that's the debtor that should worry that either the trustee, the U.S. trustee, or a creditor can bring a motion objecting to the bankruptcy either in part or that death sentence in its entirety.
You know, you talked about, the Corvette that didn't make it or the property in Wisconsin. When I do a Chapter 7, fresh start, is there any property that I can keep?
Yes, you can keep a lot of property in a Chapter 7, which is why it's a good idea to disclose everything to your attorney. For example, real estate. An individual can protect up to $15,000 worth of equity in real estate. And if it's a joint case, husband and wife, they can protect up to $30,000 worth of equity. They can protect all of their 401k. They can protect their pension. They can protect injury proceeds.
For
up
like
to
a workers'
$7,500.
compensation?
Workers' compensation is 100% protected as long as there's not a third-party claim against machinery manufacturer or another individual.
How about like a garden variety auto accident case?
Well, any kind of minor auto injury is not going to bring a return high enough for the trustee to take. There's a $7,500 exemption. So the first $7,500 that an individual recovers in his pocket would be protected.
Excluding any attorney's fees that he's paid or costs.
That's right. I'm talking about the net, the final amount that the individual gets. Also, vehicles are protected up to $2,400 in equity each. And there's a $4,000 miscellaneous, what they call wild card exemption, which can be sprinkled over any kind of personal property. So you can use the auto exemption for $2,400 and whatever's left of the $4,000 wild card to protect a vehicle as well. So you can technically have more than $2,400 equity in a vehicle. And most debtors in a bankruptcy are not in a positive equity situation with their vehicles anyway.
What happens, for example, let's just say I have a Harley and we've gone through the wild card and the $2,500 exemption. I mean, am I going to lose it?
You have a couple choices with regard to a Harley that has equity or a paid-off vehicle. You can either surrender it to the trustee in exchange for your fresh start. Trustee will then sell it, administer the asset, pay the creditors a pro rata share. Or you can keep the Harley, but you're going to have to buy out the trustee's interest. And that's something your attorney would have to negotiate with the trustee. Typically, people do not want to give up their cars, their motorcycles, their prized possessions. In those cases, they would much rather negotiate with the trustee, eliminate their debt, but realize that they have to pay something to the trustee in exchange for that fresh start. And that's where the liquidation element comes in. They're liquidating their non-exempt or non-protectable property in exchange for that fresh start. And sometimes it's well worth it.
Well, Dave, after you do a bankruptcy, I mean, a lot of people are under the impression that, hey, that's the death blow. I'm never going to get credit again. Is it true?
No, it's not true at all. It's a common concern, that's true, but it's not true that there will be no more credit. In fact, debtors are getting offers for credit immediately upon filing because certain lenders and credit card issuers are sending solicitations to the filing list. I'm talking about auto lenders, certain credit cards that have high interest rates and annual fees, and different other entities that want to jump on this type of market for a couple reasons. First, it's going to be profitable for them. They're going to be able to take advantage of people's desire for credit and their willingness to pay up for it. And two, the lender understands that the debtor cannot file a Chapter 7 bankruptcy again for the next 8 years.
So that makes them a good bet then.
Very good bet, because in the worst case scenario, they can collect upon that debtor. But what they really hope for is that the debtor pays the annual fee, manages the credit to the point where they're paying high interest rates, and the credit card trap starts up once again. So yeah, I tell clients all the time, don't be concerned about credit. Don't be concerned about your credit score. There is life after bankruptcy, a pretty good life in that. You've wiped out your debt. You're going to get offers again. Be cautious. Be careful. Don't jump into the same bad habits that led you into bankruptcy in the first place. I want to see clients get out of debt and not come back to me every 8 years. Unfortunately, there are some that do come back every 8 years They
Like
mark the
clockwork.
they mark the date on the calendar. They know when they could file, and they're doing what got them into trouble in the first place, and it's a shame.
You know, you talked a little bit earlier about the debt management course, which was a precursor before you can actually file, right, your petition for bankruptcy or Chapter 7. Is there anything else that's required after that?
Yes, there is one requirement after you file, and that's you have to take a 2-hour personal financial management instruction course. This is something that the government put into place in the 2005 law change that basically said you're going to take credit counseling before you file, and you're going to take financial management instruction after you file to actually get your fresh start. And what this course is, it covers everything from insurance, purchasing a car, banking, smart decisions financially. A lot of this stuff was covered in high school courses and collegiate courses, but it's just another reminder to avoid some of the scams, take responsibility for what you do, make smart decisions. Most of the clients have said that they do pull something valuable out of this 2-hour course. And there's also a little quiz that they have to take at the end. The government mandates that they pass this quiz. If they don't pass the quiz, the provider just needs to give them a little bit more counseling, talk to them over the phone, explain what area they fell short in. But typically, most of the clients get 100%. So you can tell it's not a difficult quiz, but they're just trying to protect people going forward so that they don't fall into these same traps.
What can I expect to pay for a Chapter 7 bankruptcy?
The fees for bankruptcy are going to vary. It's widespread. It's anywhere from $700 to $800 at the low end, $2,000 or more at the high end. And we're talking about a service here, so you're really paying for that service. Some attorneys give you very little treatment, very little explanation, very little help. Other attorneys help you all the way through. They make it a smooth process for you. They take care of most of everything for you. And of course, there's a different level of expertise between a novice attorney or an attorney with very few years of experience, and then someone who's got 20 to 25 years experience who has seen a wide range of issues. So you're paying up in certain cases for a more knowledgeable, more experienced attorney, but it ranges. So I tell people to shop around. You often get what you pay for, but not always. Sometimes you overpay for bad service.
Yeah, true.
And you got to be very careful. So I recommend clients look on the internet, look at some of the reviews, check out the websites, and most importantly, visit that attorney's office. Meet with the attorney, see what he's all about or she's all about. Get a feel for whether your questions were answered. Was the staff helpful? Did the office look presentable? Did they look like they were doing business there? Are they doing bankruptcy and injury and divorce and foreclosure? Or are they really primarily a bankruptcy law firm? So it's very important. I say you go to a specialist.
Well, let me ask you this, okay? I work at a bank, so is my employer going to find out if I do a bankruptcy?
Well, your employer is typically not going to know about your bankruptcy unless he or she needed to be notified. For example, if a client is being currently garnished and they come in for a Chapter 7 or a Chapter 13 and they want to stop that garnishment, we're going to have to send proof of the bankruptcy filing over to the payroll department. So in that limited circumstance, your job is going to find out. But typically, your job doesn't need to know. They're not listed as a creditor. They don't get notice of the bankruptcy. You're not going to have to disclose it if you're already working there. So that is a major concern that some people have, but typically, your friends, your family, your job, they're not going to know about your bankruptcy. Even though it's public record, it's primarily private in nature.
Well, what's going to happen? You talked a little bit earlier about an automatic stay, that certain lender or certain creditors can't continue to collect on a debt and they have to stop. What happens if somebody calls me after I filed?
Well, you're going to continue to get collected upon, is that what you're saying?
Right. What happens if they continue to call me at work and they continue to call me at home and they continue to try to garnish my wages?
Okay. If you've already filed for bankruptcy and you have the case number, the date of filing, and the automatic stay, a typical creditor cannot pursue collection actions. And if they do, your attorney has the ability to, one, send them additional information to get them to stop, and two, could bring an action for sanctions for violating the automatic stay. I mean, it goes totally against the Fresh Start principle that once you file, you're free from collection activity. And most creditors know this, and they don't want to fall victim to a bankruptcy judge entering a monetary sanction. But every once in a while, you get either a rogue collector or an individual collector who doesn't really know the laws, and they continue to pursue the debtor. I typically can get that to stop with a phone call or a letter, but on rare occasion, we do have to bring it back to court and hammer them with a sanction.
To get them, and this is the principal difference between just a consolidation place and the protection of the federal bankruptcy laws.
Okay, you're talking about, yeah, there's a misconception out there that debt consolidation is going to bring this tremendous protection and consolidate all the debt and give you one place to pay and lower your amount. The problem with that is debt consolidation does not have the backing of the federal law behind it. So if 8 out of your 10 creditors decide to take the payment plan, but 2 don't, and those 2 sue you and garnish your wages,
You're out of luck.
you've accomplished nothing.
Right.
Plus, in the past, a lot of debt collection or debt consolidation companies have not really helped the debtor in the long run. The debtor has made payments that have gone towards creditors, but also to the collection agent or the collection firm
As a fee.
as a fee, and it hasn't really brought the relief that the debtor really can get by filing an actual bankruptcy case.
So let me ask you this: if I'm going into your office, what do I need to bring
Well,
in terms of paperwork-wise?
Well, you're going to want to bring everything that you have in terms of your debt. So statements, lawsuits, any kind of collection letters, you want to bring those with you. You also want to bring your most recent federal tax return for a Chapter 7. If you don't have that right away, it's okay, but it's a good thing to have because the attorney's going to demand it at some point. You want to bring proof of your income, very important. The attorney has to make sure that you qualify. So you have to bring in a recent paycheck stub or a Social Security statement or an unemployment benefit statement. And then, of course, you want to bring yourself, and you want to be ready to be open, honest, and learn a little bit from the attorney. The attorney's going to have to interview you, and the attorney's going to ask some personal questions about what you make and what you spend and go over the budget and who you owe.
I've had people who were clearly not telling me the whole situation.
Yeah.
In those situations. Well, Dave, look, I know we don't have a lot of time. Let me ask you one more very important. It's a viewer question. It's from Larry in Joliet, and this is a common question. He says, "Will it ruin my wife's credit score if I file bankruptcy and not her?"
It will not. What happens is if it's his debt alone, she's not part of it, he would be filing under his Social Security number, all of his creditors would be listed, he would have to appear. Her credit would not be affected. The only exception would be is if they had some joint debt and he files a bankruptcy and she doesn't, because now the creditor can pursue her.
But she's still on the hook, but that's not necessarily going to affect her credit if she pays for it.
There may be a line item that says someone else filed the bankruptcy on this debt, which in this case the wife can explain, it wasn't me, it's not my social, I'm paying for it.
Right.
So there might be a slight credit hit, but it could be explained away to a lender or any other person. So
Very good.
Okay, Jesse, that's all the time we have for today. Thanks for the great question, as well as some general information about bankruptcy. You've been watching Legal Action. We'll see you next time. Take care. Bye-bye.